If you've ever lived in a place with a homeowners association, an HOA, you know that things can get tense. But what happens when just asking to see how your neighbors voted blows up into a full-on court case? Well, that's exactly what we're digging into today. This is the story of how one community's fight over ballots put the whole idea of transparency on trial.
And really, it all boils down to this one question. It's that classic tug of war, right? A homeowner's right to know versus the association's duty to protect its members. So where does the law actually draw the line? Is it even legal for your HOA to keep votes a secret, even from its own members?
Okay, so let's set the scene. We're in a residential community in Chandler, Arizona. A group of homeowners found themselves totally at odds with their HOA board, and what started as a pretty standard request to see some records quickly spiraled into a legal battle that really pushed the limits of what transparency means.
So how did we get from a simple question to a lawsuit? Well, it all started back in January of 2020. Some homeowners asked to see the recent voting records. The HOA board said, sure, but you have to sign this non-disclosure agreement first, basically a gag order. The homeowners said, no way. A month later, the HOA finally hands over the records, but they do something weird. They give them the ballots in one stack and the signed envelopes in another, so you had no way of knowing who actually voted for what. By September, the homeowners were fed up and felt like they had no other choice but to sue.
All right, so let's put ourselves in the homeowner's shoes for a minute. From their point of view, they had a crystal clear right to verify the election results, and they felt the association was deliberately stopping them from doing just that.
The whole heart of their legal case really comes down to this one phrase. They argued that by giving them records that were impossible to actually check, the association had put up an unlawful barrier to their rights as members of the community.
Look, their position was pretty straightforward. What good are records if they're completely useless? By separating the ballots from the envelopes, the HOA made verifying the vote totally impossible. They argued this wasn't just being difficult, it was a violation of the law, which says records have to be reasonably available. And, in their eyes, two disconnected stacks of paper were anything but reasonable.
But of course, the HOA had a totally different story. For them, this was never about hiding anything. It was about juggling all of their responsibilities, and some of those went way beyond just transparency.
This quote from the HOA's lawyer really sums up their entire defense. They didn't just see themselves as record keepers. No, they saw themselves as protectors of the whole community, and that meant they had to balance one member's request against the privacy and safety of all owners.
So the association's defense really hinged on a few key things. First, they said, hey, we did give you all the documents you asked for. And they pointed out that while the law says records have to be available, it doesn't say how. They even cited past complaints of harassment, arguing they had a duty to protect their members. So for them, separating the ballots wasn't some kind of roadblock, it was the only way they could walk that tightrope between transparency and privacy. And this is where we get to the core of the conflict, the real stalemate. You've got the homeowners on one side saying, we need to see who voted how. This is about transparency. And on the other side, the association is saying, we have to protect voter privacy. This is about safety. Both sides were absolutely convinced they were in the right, and there was just no obvious middle ground.
It's pretty wild, but this entire court case, all this conflict, it ended up boiling down to the legal meaning of just two little words in an Arizona state law. Everything hinged on what it actually means for records to be reasonably available.
So here it is. This is the exact law at the heart of the whole dispute. It says an association's records have to be made reasonably available for any member to look at within 10 business days. But here's the catch. The law never actually defines what reasonably available means. It doesn't specify the format or anything. And that little bit of legal gray area, that's where this entire fight happened.
So, you've got one side screaming transparency, the other defending privacy, and it all landed on the desk of an administrative law judge to sort it out, to interpret the law and finally make a call.
So who won? Did the judge decide that providing records you can't actually match up was illegal? Or was the HOA's weird two-stack method actually a reasonable way to balance everything? What do you think?
The judge's decision was unambiguous. The homeowner's petition was denied. The judge came to the conclusion that the association had not, in fact, violated the statute.
So why? Why did the judge land on the association's side? Well, the whole thing came down to that one word, reasonable. The judge even admitted the HOA's method was not ideal, but, and this is the key part, it was still reasonable. The homeowners did get every piece of paper they asked for, and since the law doesn't say anything about the format they have to be in, the judge basically concluded that no rule was technically broken.
So this case leaves us with this huge, lingering question that honestly applies to almost any group we're a part of, way beyond just an HOA. Where do we draw that line between a community's right to know and a person's right to privacy? And when we're all searching for accountability, how much access is too much?